Welcome back to Organized, the business law breakdown. I'm your host, Professor Seth C. Oranburg, and today we're diving into another fascinating aspect of contract law, anticipatory repudiation. What happens when one party announces they won't fulfill their end of the bargain before their performance is even expected or due? Stick around as we explore this legal concept and its implications for contract enforcement. Imagine you've signed a contract to buy a house, but a week before closing, the seller tells you they've decided to keep the property. What can you do? Today, we'll uncover how the law handles these situations and what remedies are available to the injured party. By the end of this episode, you'll understand the concept of anticipatory repudiation, how courts determine if an anticipatory repudiation has occurred, and what options are available to the party who's harmed. Before we get started, let's discuss three key concepts you'll learn from listening to this episode. First, you'll learn what constitutes a sufficiently clear indication of a party's intent not to perform, such that you know what anticipatory repudiation is. Second, you'll discover the choices available to a party who's faced with anticipatory repudiation. And third, you'll understand how parties can request and provide assurance of future performance. So if you've ever wondered what happens when someone backs out of a deal or causes reason to worry before it's time to perform, stay tuned. We'll break down these concepts and show you how courts handle these tricky situations. Let's dive into the key concepts of anticipatory repudiation. At its core, anticipatory repudiation occurs when one party to a contract, through words or deeds, clearly indicates that they will not perform their contractual obligations before the time for performance has arrived. Now remember, if they don't perform at the time performance is due, that's a breach, and we have a separate episode on that topic. Here we're dealing with a situation where performance is not due yet, but there's reason to believe it's not going to happen. What is an anticipatory repudiation is defined under common law as either a statement by a promisor indicating they will breach, or a voluntary, affirmative act making performance impossible or improbable. By the way, a other situation, as in not a voluntary act, but as they say, act of God, can create a situation called impossibility or impracticability, and we discuss that situation separately in the topic of excuse. Back to anticipatory repudiation. Statutory law generally mirrors common law in terms of what options are available to a party facing an anticipatory repudiation situation, and there are three options. First, wait a reasonable time for performance, which effectively waives the repudiation. Second, suspend their own obligations, basically refusing performance until the repudiation is retracted, in what's called self-help. Or third, treat the canceled contract as breached and go ahead and sue, enlisting the courts for help. So let's understand what constitutes anticipatory repudiation, because it's not just any statement or unreasonable uncertainty about future performance. A repudiation must be clear and unequivocal. For example, if a seller of goods tells a buyer, I've decided to keep the items for myself, I won't be delivering them to you. That's a clear repudiation. On the other hand, if a seller says, I'm having some production issues and might be a bit late, that's probably not enough to constitute repudiation. Another important concept is the right to request adequate assurance of performance. If a party has reasonable grounds to believe the other party won't perform, but those grounds don't rise to the level of anticipatory repudiation now, the party who has doubts can demand adequate assurances. And if the assurances aren't provided within a reasonable time, the failure to provide assurances can be treated as a repudiation. Lastly, it's critical to understand that anticipatory repudiation can be retracted in some cases. If the non-breaching party hasn't materially changed their position in reliance on the repudiation, the repudiating party can generally retract the repudiation and promise to proceed with the contract. Let's break down a key case that illustrates the concept of anticipatory repudiation and its legal consequences. It's a historic case from 1853 in England called Hoster versus De La Torre. It's considered the foundation of modern anticipatory repudiation. In this case, a courier was hired to accompany a client on a 3-month European vacation starting on June 1st. On May 11th, before the journey began, the client repudiated by clearly stating they no longer needed the courier's service. The courier sued immediately. In fact, the courier went out and tried to find another job for the summer. And the client defended on the grounds that there was no breach because the time for performance had not yet come due. The court established the doctrine of anticipatory repudiation by holding the courier could sue immediately rather than requiring waiting until the performance date. And this decision reflects two key policies. First, allowing immediate action prevents the non-breaching party from being stuck in limbo and allows them to, second, mitigate damages by seeking alternative arrangements. The court's reasoning is it's unfair and inefficient to require the innocent party to wait until the time for performance, potentially missing out on other opportunities, when the other party has clearly indicated they're not going to perform. The decision laid the groundwork for the modern doctrine of anticipatory repudiation. The takeaways from this case are, first, a clear, unequivocal repudiation before the time for performance can be treated as an immediate breach, giving the right to cancel the contract and do something else with your time. The non-breaching party, second, doesn't have to wait until the time for performance to take legal action. And third, this doctrine allows innocent parties to mitigate damages, which, as we'll learn in our damages modules, is one of the requirements for collecting damages. The case demonstrates how contract law adapts to practical realities. It just wouldn't be fair or efficient to force parties to wait for a breach they know is coming. What's the point of that? The doctrine of anticipatory repudiation allows for flexibility and fairness in contract enforcement. So, anticipatory repudiation occurs when a party makes an unequivocal statement of an inability or unwillingness to perform, giving the non-breaching party several options. First, treating the repudiation as an immediate total breach. Second, suspending performance, effectively treating the repudiation as a partial breach, as a material breach, and allowing further developments while not providing any more consideration. Or third, to simply wait until performance is due and to hope for the best, perhaps with urging performance or demanding adequate assurances, as we'll see in a moment. But first, let's explore some what-if scenarios to test your understanding of anticipatory repudiation. What if a baker has a contract to deliver 1,000 loaves of bread to a restaurant every Monday? On Sunday evening, the bakery owner calls and says, "We are not delivering the bread tomorrow. Our ovens are broken and we won't fix them for weeks." First, is this a repudiation? Yes, this is clearly a repudiation. There has been, first, an unequivocal statement demonstrating an intent not to perform. There's also circumstances showing inability to perform. The broken ovens mean no bread. So what can the restaurant do? Well, first, they could sue immediately, citing anticipatory repudiation, which is treated like a total breach. Second, they can suspend their payment obligations while seeking assurances that the bakery can fulfill future deliveries, thus treating the anticipatory repudiation as grounds for assurances and as a material breach. And, by the way, they can secure bread from another bakery and claim the difference as costs and damages because they can now go and mitigate those damages by finding another supplier. What should the restaurant do? Should is a harder question of legal strategy. This introductory podcast doesn't delve into legal strategy, but we'll address those advanced concepts in future seasons. What if a company contracts to buy 1,000 widgets from a supplier to be delivered in 3 months? 2 months before delivery, the supplier emails saying, "We're having some production issues and might be a week late with delivery." Now, this scenario is trickier. The supplier's statement doesn't expressly say they won't perform. It does express some doubt about timely performance, but it doesn't indicate they won't perform at all. This probably won't constitute anticipatory repudiation. Of course, there are factors to consider, like whether time is of the essence with this particular supply contract, and the buying company may have grounds to request adequate assurance of future performance. We'll break down adequate assurance next. Scenario 3, what if a homeowner hires a carpenter to renovate their kitchen starting next month? A week before the construction begins, the homeowner drives by the carpenter's shop and sees the shop burned down. This is probably another case of anticipatory repudiation. Due to the circumstances, the reasonable homeowner would believe the carpenter cannot perform. The homeowner doesn't have to wait until the start date to take action. They could probably immediately start looking for a new contractor and sue for any increased cost or delays caused by the repudiation, unless, of course, that fire would excuse the carpenter from performance. And we'll talk about excuse in another episode. These scenarios illustrate how anticipatory repudiation plays out in real-world scenarios. The key is to look for clear, unequivocal statements or actions that indicate an intent not to perform. Let's break it down again with a look at a slightly more complex concept, the concept of reasonable insecurity. Now, this means one party is reasonably uncertain the other won't perform, but we don't quite have an unequivocal anticipatory repudiation yet. This is where the doctrine of adequate assurance of future performance becomes crucial. And we're going to break it down with the application in Hornell Brewing Company versus Spry, which involved tasty Arizona iced tea products. Hornell Brewing Company granted exclusive distribution rights over Arizona iced tea in Canada to a man named Stephen Spry and his company. Over time, Spry purchased a lot of iced tea, but he didn't pay for it, with unpaid invoices growing from $20,000 to over $100,000. A $31,000 check was returned for insufficient funds. And by the way, if you don't have $31,000 in your bank account, you certainly don't have $100,000. Despite Spry's promises to pay, he failed to secure a reliable line of credit or to demonstrate financial stability. Hornell kept asking for adequate assurances that Spry could meet his future obligations and eventually required proof of a line of credit from a reputable lender and adherence to payment terms. Spry failed to do these things and demanded more iced tea anyway. He did pay his bill for some of the iced tea and then placed a much larger order without showing that he had any line of credit. Hornell terminated the distributor agreement and didn't provide the tea. Ironically, Spry then claimed Hornell breached the distributor agreement. This shows how getting anticipatory repudiation analysis wrong is risky. If you wrongly believe your counterparty repudiated and cancel the contract, now you're the one who's in breach. The court, however, ruled for Hornell because Hornell had reasonable grounds for insecurity about Spry's ability to perform, and Spry failed to provide adequate assurances. Failure to provide adequate assurances is functionally effective as an anticipatory repudiation, and so Spry's effective anticipatory repudiation gave Hornell the option to cancel the contract and sue for breach. This case illustrates a few key principles. First, regards reasonable grounds for insecurity. What is it? In this case, Hornell had sufficient reasons to doubt Spry's ability to perform, which came from facts like overdue payments, bounced checks, and unmet financial projections. Hornell's demand for proof of credit was reasonable, and this brings up the point that demands for assurances have to be reasonable. They have to be in line with the insecurity. And demanding a proof of credit before shipping $400,000 of tea to Canada is consistent with industry norms. Finally, Spry's inability to meet the requested reasonable terms was a failure to provide assurances, and that justified Hornell's decision to cancel the contract or suspend their performance. The doctrine of adequate assurance offers a practical safeguard against performance risks in these uncertain situations. By proactively addressing insecurity, parties protect their interests while maintaining flexibility to respond to evolving circumstances. Let's turn to pop culture for a moment. Remember that hit TV show Friends? There's an episode that perfectly illustrates anticipatory repudiation. In the episode, The One with the Bullies, Chandler and Ross are at a coffee shop when two bullies take their favorite seats. The bullies challenge Chandler and Ross to meet them at Central Park at 7 p.m. for a fight over seats at a coffee shop. Chandler and Ross agree, but they have no intention of showing up. Now, this is an absurd example and it's not an enforceable contract, but let's have fun by looking at it through the lens of contract law. Let's imagine that Chandler and Ross have essentially entered into a contract. By deciding not to show up and openly discussing their plan to avoid the fight, they're engaging in anticipatory repudiation. If this were a legal contract, and it's not, the bullies, as the non-breaching party, would have several options. First, they could treat Chandler and Ross's decision as an immediate breach and take action, although I'm not exactly sure what they would sue for. They could wait until 7 p.m. to see if Chandler and Ross show up, which is basically waiving the repudiation. Or they could urge Chandler and Ross to reconsider and follow through with their agreement, demanding adequate assurances of the fight performance. Of course, in the show, the situation is for laughs, and I'm sure we're all glad Chandler and Ross didn't go through with the fight. They probably wouldn't have won. But it's a funny example of how anticipatory repudiation can occur in everyday situations. Let's recap what we covered today. We covered two critical doctrines in contract law which are related: anticipatory repudiation and the right to demand adequate assurance. Both doctrines address situations where performance under a contract is uncertain, but they apply in different ways. Anticipatory repudiation occurs when one party clearly communicates, through words or actions, that they will not perform some obligation. Under the common law and the Uniform Commercial Code, the non-breaching party can treat this as a total breach, immediately suing for damages or suspending their own performance. For example, in Hoster versus De La Torre, the court allowed the non-breaching party to act immediately, which helps mitigate losses and doesn't require waiting for the breach to occur. Reasonable insecurity and adequate assurance provide a safeguard when a party's performance is uncertain but not yet repudiated. The concerned party can demand some assurance, in case of sales, written assurance, of performance if they have reasonable grounds for this insecurity. And as we saw in the Hornell Brewing case, the iced tea case, Hornell's doubts about Fry's financial stability were justified by his missed payments and bounced checks. So when the buyer failed to provide assurance of credits, Hornell was entitled to terminate the agreement. Both doctrines serve as tools for managing uncertainty in contractual relationships. If you found this episode on anticipatory repudiation insightful, please share it with your colleagues or classmates. Your support helps us reach more people interested in understanding the intricacies of contract law. Don't forget to subscribe so you won't miss our next episode, where we'll explore how parties can agree to change their own agreements, and we'll explore when parties are excused from their performance because of acts of God or force majeure. We'll be diving into the fascinating world of contract modification and excuse, and really putting a bow on what makes contracts enforceable. If you have any questions or topics you'd like us to cover in future episodes, please reach out through our website or social media. Your input helps shape the content of this podcast. That's all for today's episode of Organized, the Business Law Breakdown. I'm Professor Seth C. Oranburg, and I thank you for tuning in and exploring the world of anticipatory repudiation with me today. I hope you found today's session informative and helpful in understanding how contract law handles situations where parties indicate they won't perform before performance is due. And remember, until next time, keep your agreement strong and your argument stronger.